Drafting best evidence. So it's a phrase which are used by lawyers to describe evidence which has been prepared in compliance with a number of rules, but also in compliance with what those in the profession consider to be best practice. So some of the rules I'm going to be referring to today are really technical in nature, and they're actually really difficult for experienced lawyers to understand, let alone non-lawyers. So what I'm going to try and do is tell you what the rule is, and then I'm going to try and explain it by way of an example, because the way that some of them are worded is just very, very difficult to understand. Now, the rules that I'm going to discuss apply to adoption proceedings whether or not they're contested, so both uncontested and contested. So the starting point when you're drafting evidence or even conducting casework is to have these rules at the back of your mind. If the rules are not followed, then as my friend said, objection can be taken and the evidence actually might not be allowed in. And what this means is that you actually might end up with gaps in your case, or you might not be able to prove some of those formal matters which I went through earlier today. And as I said, the court has to tick off every single one of them, so you're actually risking not being able to present a fully adequate case to the court. So the first rule is that evidence must be relevant. And I should mention the 4 rules that I'm talking about are covered in the Evidence Act, which again I mentioned earlier today. So the Evidence Act essentially says that if accepted, the evidence could rationally affect the assessment of the probability of the existence of a fact in issue in the proceedings. What does that mean? So, as I said, I'm going to use an example. Earlier today, I went through all the Section 8, Subsection 2 factors, the matters the court has to consider which is in the best interest of the children. And you'll recall that I talked about a couple which related to the proposed adoptive parents and also about the child's needs, so that the proposed adoptive parents are able to actually meet the needs of the child. So, relevant evidence might be details of how the proposed adoptive parents have assisted a child with speech exercises, and that is going to be relevant to proving the fact that they can meet the needs of the child. Does that make sense? So that's why it's relevant. The second rule is that hearsay evidence is not admissible. Is anyone familiar with this phrase, hearsay? Yep, good. Okay, so the Evidence Act says, hearsay is a legal term for testimony or evidence in proceedings where the witness does not have direct knowledge of the fact asserted, but knows it only from being told by someone, i.e. Becky told me Tom was in town, as opposed to I saw Tom in town. Can everyone recognise that distinction? The third rule is that a person's opinion is not admissible. Now, there are some exceptions which I'm going to talk about later today, but examples of opinion include something like the child's contact should be reduced from 6 times a year to 2 times a year. Or another example might be the father was angry during contact. Okay, so that's my opinion that the father was angry during contact. Really, the only person who can say whether or not the father was angry is the father. So generally, those types of opinions are not admissible in evidence. And I'm also just going to briefly draw your attention to this concept of privilege. So the Evidence Act calls it client legal privilege, and that's essentially when you approach either an in-house or external legal counsel or lawyer to give legal advice about a particular issue in the context of proceedings or upcoming proceedings. So that legal advice is a privileged document, and you are not allowed, you do not have to produce that to the court if you were requested to. Having said that, the privilege belongs to the client, and you are able to waive that privilege. So if you want to give it to the court, you could. But going back to our rule of relevance, query whether or not a lawyer's opinion about something is really going to be relevant to proving the facts in the case or those formal requirements that I talked about. It's really not going to be the type of evidence that you're after. So I really can't think of many situations where you would want to waive that privilege. Okay, so we've established these rules and that they apply in adoption proceedings. But there are 3 exceptions which I'm going to go through. The first is Section 126 of the Adoption Act. In respect of hearsay evidence, I'm going to tell you about the business records exception. And then in respect of opinion evidence, there's actually two ways out of it. The first being if you have specialised knowledge, and the second being what we call lay opinion. So I'll address each of these in turn. So Section 126 of the Adoption Act says, except as otherwise provided by this Act or the regulations, the court, in the hearing of any proceedings or in determining any application or matter under this Act or the regulations, may act on any statement, document, information or matter that may, in its opinion, assist it to deal with the matter of the proceedings or before it for determination, whether or not the statement, document, information or matter would be admissible in evidence. So this is essentially saying that even if you don't comply with the rules I've just talked about, it can go in anyway. So you're sitting here thinking, well, why did you just waste 10 minutes of our time talking about really difficult concepts that, we didn't really understand until you provided the examples? Well, the answer is, whilst yes, that evidence can go into the proceedings, it's given less weight by the judge. So if you try and comply with those rules, the judge is going to give more weight to your evidence. But if that's not possible, then don't worry, we have Section 126 which we can rely on. So moving to the business record exception, this applies if the documents form part of the records kept by an organisation, such as Fax, Anglicare, Bernardo's, in the course of or for the purpose of a business, and if the representation was made by a person who had or might reasonably be supposed to have had personal knowledge of the asserted fact, or on the basis of information directly or indirectly supplied by a person who had or might be reasonably be supposed to have had personal knowledge of the asserted fact. Okay, so using examples again. Just say that you have a child who has been diagnosed by a doctor with attention deficit disorder, and a report's prepared by that doctor and given to you as a caseworker for the child. Well, that's a document which then forms part of your records as an agency, and it's in the course of your role in case management of that child's the casework, and it's a representation which has been made by a person who had or might reasonably be supposed to have had personal knowledge of the asserted fact. The doctor knows that the child has ADHD, it's in the report forms part of your business records. Hence, you could use that report in evidence. Another example might be a contact record. So a contact supervisor has observed a contact visit, made a number of observations. Again, that record forms part of your business records, and we can assume that the contact supervisor was aware of the facts that are in the report. They've seen them, heard them, and observed them, so have written them down. Another example might be material which is obtained under Chapter 16A of the Care Act, maybe from police. Again, it forms, once you make the request and the documents are sent to you, it forms part of your business records. It's part of your casework in relation to the child. And we can assume that the police officers that were making those notes, perhaps in the COPS events, were aware of the facts in those reports. So they're three examples of business records. I guess just leaving 16A aside because there's other considerations when you have proceedings as to whether or not you can rely on them. Okay, so moving on to our opinion rule exceptions. Opinions are actually allowed in evidence if it's based upon specialised knowledge. Now, the way that we work out specialised knowledge is if someone has had training, experience, or particular knowledge about a particular area, such as social work. So, Deb, how long have you worked in adoptions again?
1987, I can't add up.
Since 1987, and neither Deb or I can add up, but you can. So if I was preparing an affidavit from Deb, I would set out how long she'd worked in the area. I'd set out her university and tertiary qualifications. I might set out some papers that she'd written, and I would establish her as someone who has specialised knowledge in the adoption arena. And if I establish that, then that means that she can actually have opinions about particular things that a person that doesn't have that experience couldn't. So for example, myself, I'm legally trained. There are just some concepts that I as a lawyer don't understand or have specialised knowledge about. Okay, so that's one exception. And I should just say, you have to really question whether or not the specialised knowledge is generally known in the community or whether it's a belief about something. It has to be more than that. It really has to be linked to your qualifications, experience and training. Now, the second exception I said was called the lay opinion. And again, the way that the Evidence Act talks about it's quite wordy, but essentially the opinion is not an expert opinion and is based on what a person saw, heard or perceived about an event, and that evidence is necessary to obtain an adequate understanding of the event. Again, I'm just going to use an example because I think that's the easiest way of explaining it. So before I used an example about the father being angry during contact and how that was my opinion. The court might let in my opinion that the father was angry to explain why I had terminated the contact visit or that contact had been suspended. So if one of the facts in dispute in the proceedings is whether or not contact should continue because there have been issues, they will allow my opinion in that the father was angry to accept the evidence about why it was suspended or terminated. So that's a lay opinion. Okay, so direct evidence is when you have directly seen or heard something. And the reason, there's kind of three key reasons I want to talk about why we say direct evidence is best. The first is that there's less room for error or misinterpretation. Is anyone familiar with that game Chinese Whispers, where you sit in a circle? I used to play it as a kid and I always remember being surprised by how much a statement could change as it went around the circle. Like it was amazing. I was like, how did you hear that? That was nothing like what I said. So that's a perfect way of explaining why direct evidence is best, okay? Because it avoids that possibility that something's misinterpreted or taken out of context. The second reason is that it means that you can give greater detail and clarity about evidence. And I guess this is most important when you're actually in contested proceedings and you have witnesses called to give evidence. Obviously, when you're in the field preparing file notes, you're not going to write down every little single thing about an event because that's just not humanly possible. So often your file notes end up just being summaries of kind of what happened. But what often happens in court is that you're asked further details about what's in the file note. And if the person that prepared the file note isn't your witness, then they can't expand on what's in the file note. So let's go back to the example about a father being angry in contact. They might be asked, well, why was the father angry? What was it about him that made you think he was angry? And the deponent would say, well, I don't know. Whereas if you are the witness, you can say, I formed the view because he leaned forward and his brow was sweating and he clenched his fists and his voice raised. So you have all of this additional information and evidence which otherwise wouldn't be available. And then linked to that, in your proceedings, the father might be the defendant. And if you don't have the person that had direct knowledge of that event, you might have the father get in the witness box and say, oh, I wasn't angry, we did have a disagreement, but it was very pleasant. The child would never have known. Our voices were very low and it was almost like we were talking about the weather. And potentially you can't argue to the contrary to that because you don't have the witness directly there. So that's kind of why we say direct evidence is the best evidence. So now you're thinking, well, that's all well and good, but this child has 20 caseworkers that work with the child. Are you saying we have to file 20 affidavits? No, because that's just going to be too difficult. It's just not possible. So, I mean, in most of my cases, we generally have the delegate and then we might have the caseworker or the regional adoptions caseworker that works with the family the most as our witnesses, which means that you are going to have a number of business records which isn't direct evidence. So then the question becomes, well, what business records do you choose to annex? And the answer is you should always attach either the source or primary record rather than any summary or secondary record. I'm going to use an example again. So if you have this book handy and you turn to page 31, it's a contact record. Can I just give you a couple of minutes just to have a read through that? Okay, so the contact report's what I call a source or primary record, and that monthly review is a secondary or summary. Can you just turn to the person next to you and have a chat about why you think the primary document is better evidence than the secondary document, or whether there was anything that you noticed, I guess focusing on the contact summary in the monthly review? Were there any issues? So I guess it shows there's a risk of making mistakes. So something as simple as the date, which isn't a huge deal, but it's incorrect. The contact report says that there's no concerns, and yet the impression I kind of got when I read the monthly review is that there were some concerns because Jane was immensely upset. The venue is incorrect. So I guess what I'm trying to demonstrate is that the primary record is a better and more accurate, contemporaneous record of what happened. Issues with summaries is that people make mistakes. A different person might have prepared the monthly review. So again, they've got no direct knowledge of what happened at the contact. It's open to interpretation and misinterpretation. So that's why we generally say that source records should be attached to affidavits as opposed to any summaries. Okay, just some tips when you're drafting evidence, and I touched on this earlier today, that it's really good to use subheadings because it makes it really easy for the judge to just kind of tick everything off. The judge knows all the matters that he or she has to consider, and you're just making their job so much easier because they can just go, oh, consents, tick, adoption plan, tick, all those section 8, subsection 2 factors we talked about, tick, 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 makes it much easier. And also, I told you earlier, Part 56 of the Uniform Civil Procedure Rules is in your handout at page 15. And Rule 56.8 also sets out a lot of matters that evidence has to be filed in relation to, and I talked about a lot of them earlier today. So affidavits should never be a chronology. It shouldn't be child born here and this is what happened. It's actually divided into more meaningful paragraphs: child protection history, children's court proceedings, contact with the mother, contact with the father, adoption plans. So you have very distinct aspects within the affidavit. Also, there should only be one point or issue raised per paragraph. If you turn to page 12 of this handout, you'll see Rule 35.4 says that in the body of an affidavit, if the body of an affidavit alleges or otherwise deals with more than one matter, it must be divided into paragraphs, and each matter must, so far as convenient, be put in a separate paragraph, and the paragraphs must be numbered consecutively. So you don't want to have long paragraphs that deal with a number of different matters. Each paragraph should only deal with one matter. Next, I'm going to talk about this concept of letting annexures or exhibits speak for themselves. I'm firstly just going to quickly explain the difference between annexures and exhibits and when you might use one over the other. So annexures to an affidavit actually form part of the affidavit. So if your affidavit is 10 pages long, your annexure A actually starts at page 11, and so on. Generally, if affidavits are going to be more than 50 pages, that's when we use exhibits. An exhibit isn't part of the affidavit itself. It sits separately to the affidavit and is in front of the deponent when they swear or affirm the affidavit. It's also not filed. It's tendered later down the track during proceedings, so it's not placed on the court file. But because, in my experience, in every adoption matter, there's so many annexures it has to be an exhibit, if we know a matter is going to be uncontested, we just, when we file the documents, request that the registrar accept the exhibits when the summons is filed, because it's going to be referred to a judge to consider in chambers. So if matters are not contested, the judge just sits at his or her own leisure in her chambers and reads everything and then decides whether or not to make the order. So that's just quickly so you understand. And again, on page 12, you'll see 35.6 talks about annexures and exhibits. So maybe just familiarise yourself with that rule as well. So this concept of letting them speak for themselves essentially means that when it's either annexed or exhibited, there's no need to verbatim repeat what's in that attachment in the body of the affidavit. This avoids the deponent taking issues out of context or giving misleading accounts of events. And I think the best way to demonstrate it is always with an example. And what we actually have is a real life example. So at page 29 of your handout is a case of re Liam. The relevant paragraphs are starting from 59 onwards. But essentially what happened was there was a family and community services caseworker who had included a paragraph in her affidavit about contact with a child. In the affidavit she said, the mother had contact with Liam as supervised by Wesley Dowmer. The mother was recorded as being visibly upset and tried to control her tears. She started talking to Liam, she tried to cuddle him, but he seemed more interested in the toys in the room. The mother was recorded as being upset that Liam didn't seem to need her. She was worried he had forgotten her, but I said not to worry. Justice McDougall then says that his clear impression was that the contact session was of no interest to Liam. But what actually happened was the birth mother had the complete contact record. She actually tendered it during the proceedings, and it's set out at paragraph 61, which I won't read. But essentially, His Honour had an entirely different view of matters after reading the whole file note, and found that overall it was a happy and apparently mutually satisfying interaction between Liam and his mother. He then went on to say, I regret to say that I found paragraph 52 of the affidavit misleading. It may be that Miss Roberto, named and shamed in this publicly available document forevermore, failed to appreciate that she had taken the material out of context or that she had given a misleading account of the contact session. Although I find it difficult to understand how one in her position could have done either of these things. He then went on to say, I draw attention to this in the hope that, in future, care will be taken to ensure that when employees of docs summarise or extract from documents that are not otherwise in evidence, they do so accurately, fairly and impartially. Now, in this case, it wasn't annexed at all to the affidavit, but in my view, best practice, even if it is annexed, just don't summarise it, because you're opening yourself up to this possibility, and it could be accidental, but possibly misleading the court, taking things out of context. Again, you might be interpreting someone else's file note. Someone might form an entirely different opinion of the contact visit. So what we learn from re Liam is just to touch the document in full and don't try to take too much out of it. It's a bit of a balancing exercise, and we're going to come to an example in a second about giving the reader enough context about what the file note that's being annexed is about, but without taking too much detail so that it becomes potentially misleading. So here, pretend that our affidavit says, during the contact visit on the 1st of April 2014, I heard the father tell the child, Mummy is in hospital, Mummy's tummy is not well. The child then said to the father, Doctor going to make her better? Did you hurt Mummy? During transportation back from the visit, the child stated to me 3 times, I hate Daddy, and then added, I love Mummy. So what picture is portrayed from those 2 paragraphs?
Domestic violence.
Possibly domestic violence. What about the child's opinion of the father? I hate Daddy? Not very good. I can re Liam. It becomes evident during the hearing that the file note which is called for also states that during the contact visit the child said to the father, I love you, Daddy. I want to come home with you. The child is also recorded as initiating affection towards the father and keeping close to him throughout the visit. So the whole file note portrays a slightly different picture to the part which has been extracted. And again, it might not have been deliberate, it just might have been what the person writing the affidavit thought was relevant. But you need to try and avoid making, that kind of, whilst we do have to file relevant evidence, you have to be careful not to take things out of context. So this is how I would draft the paragraph. The mother was unable to attend contact with the child due to being in hospital as a result of appendicitis. The contact visit was overall a positive experience for the child, although the child made some inconsistent comments about his feelings for his father. So I've put in enough context that the reader knows it's a contact visit, the mother wasn't there. We know from the additional information that it was overall positive, but then when the child went home, was being transported back to his carers, he said, "I hate daddy." So by using these words, inconsistent comments, you're kind of flagging something for the judge. Go and read the annexure in full and make your own judgment about things. Okay, so this is the way I would draft it. Someone else might draft it slightly differently, but what I've tried to do is balance between giving the reader enough information but not taking the primary document out of context or misrepresenting or making too much of a value judgment about something. Affidavits are about facts. Okay, the facts are that there was a contact visit, mum was in hospital, we've made a concession that it was overall positive and that there were some inconsistent statements. So I've said we have this rule of letting annexures speak for themselves, and this is the other reason why. If we verbatim set out what is in the attached record, this is 15 lines long, you're just really going to annoy the judge. Okay, you're going to end up with this probably a 50-page affidavit with exhibits, and the judge is just going to be sitting there thinking, some of this isn't relevant. They haven't thought about their rules of evidence. Okay, evidence must be relevant. On the 22nd of December 2009, a report was received from QE2 regarding the mother's residential stay and observations of her parenting capacity. A copy of the report is annexed at pages X to X of the exhibit. Okay, 2 lines. It's about her residential stay and observations. Okay, and then the judge can read the primary document. So that's what I would be looking for in an affidavit, as opposed to verbatim repeating exactly what's in the file note. Okay, so the deponent should set out his or her qualifications, as this will justify why they can give some of the evidence they do. Secondly, the deponent should either swear or affirm the affidavit, not both. Now, I know this seems a strange thing to raise, but in the Supreme Court, I can guarantee that if you forget to cross one of them out, you'll have some comments from the bench, because you can't both swear and affirm. They're completely different. One is on the Bible and one is just an affirmation. One is not given more weight than the other. I'm sure you're familiar with that. It's just that some people choose to take a religious oath. But when he was Associate Justice, he's now Justice Hallen, we had some referee affidavits where the referees hadn't crossed one out, and he said, "Miss Hailstone, I'm thinking I might not let these in." And I had to persuade him why he should. And there is a bit of a sneaky rule under the UCPR where you can seek to rely on affidavits despite irregularities. But I just think we should be doing the right thing. So not even in adoption proceedings, in all proceedings, make sure you either affirm or swear, not both. An affidavit must be written from the perspective of the deponent. So as I've already flagged, in adoption proceedings, we generally have a delegate's affidavit. And in my experience, often the delegate has actually never met the child, or the birth parents, or the proposed adoptive parents. So there won't be any direct evidence. And then I've seen sometimes paragraphs saying, the child is happy and healthy. And then I say, well, if the deponent's never met the child, how do they know that he's happy or healthy? So when you're coming to drafting an affidavit, question, how does the deponent know this? And then you have to explain. So did they read it in a report? Did a case manager go to the home and observe that the child was happy? So you just need to make sure that it's clear how the deponent is saying what they're saying. Some more tips. Ensure that annexures are complete and that you include clean copies of documents. So what I'm really alluding to here is, in particular, when we're exhibiting children's court documents, you might be including affidavits from those proceedings, and there might be a number of annexures to those affidavits. And sometimes I've seen people have only included the affidavits and not the annexures. So you need to make sure that you include the complete document. And often what we do in adoption proceedings is also include copies of the birth parents' affidavits for a reason which I'll explain. I think it's the next slide, in 2 slides. So again, make sure that if they have attached, certificates of parenting courses, that all of those annexures are also included. And in terms of including clean copies, I've often come across children's court documents where the lawyer's obviously been very frustrated in court and has underlined things and started or written little comments in the borders of the documents, which is not really something you want the Supreme Court judge to see. So where possible, make sure that the copies that you're including in your exhibit are unmarked. Also, if possible, include sealed copies of court documents. I've often seen community services files where the affidavit's not sealed and the proceedings might have been 10 years ago, and I don't really have any way of knowing whether or not it was just a draft or whether it was actually filed. Whereas if a document's sealed, we can guarantee that it was filed. So preference is always to include sealed copies of documents. There's a practice that you should never annex an original document to an affidavit. Original documents should always be included in an exhibit. And that's because, as I said earlier, exhibits actually don't form part of the court file. They're actually returned to you after the conclusion of the litigation. So, for example, if it was an original birth certificate, you might want that to form part of the child's life story work. And if it's annexed to an affidavit, you'll never see it again. Exhibit, it will be returned. I'm also just going to mention that at the moment the practice is actually not to attach any original documents. We're attaching certified copies of birth certificates, marriage certificates, the police checks, and so far the court hasn't had any issues with that. So that way at least you can ensure your originals are safe and sound on your files. An affidavit must include facts, not submissions. So a fact is something like the child is Aboriginal. A submission is something like an adoption plan adequately provides for the child's Aboriginal culture. Now, I've probably confused you because earlier I said that you could give opinions about certain things, and that's true. So, someone that had specialised knowledge in the adoption context might be able to give an opinion about whether or not an adoption plan adequately provides for a child's Aboriginal heritage. But as a general rule of thumb, submissions should not go in an affidavit. So it's a really grey area and is really tricky. We need to avoid duplication and repetition in evidence, both in the affidavit and exhibit. So the primary areas that I see repetition is between a court report and a delegate's affidavit sometimes. So really make sure, I guess, that if someone's preparing a court report that maybe they don't see the delegate's affidavit, that they don't try and pull all their information out of the delegate's affidavit, because then the judge is just going to end up with very similar evidence in two places. And likewise, if you have multiple deponents on affidavit, if something's covered in one affidavit, there's no need to cover it again in another affidavit. And generally, for example, if the proposed adoptive parents are directly on affidavit, well, they're probably going to be able to give direct and the best evidence about some matters. So perhaps don't cover that in your delegate's affidavit. The other place that I sometimes see repetition is, we looked at Jane's monthly review before. I've seen some records for some agencies where every month or maybe every 6 months they have reviews, and often they might be quite long documents, maybe 12 or 15 pages, and there's a lot of repetition in those documents. So generally try not to exhibit all of them, because the judge is just going to be reading the same thing over and over again. Just extract what's relevant. Okay, so there's a rule, Rule 56.3, which is at page 16 of that handout. In adoption proceedings, this is known as the duty to make full and frank disclosure, and it provides that each party to proceedings in the Supreme Court under the Adoption Act has a duty to the court to make known fully and frankly all matters relevant to the making of an adoption order, whether those matters tend to support or tend not to support the making of the order. I.e., you need to include the good, the bad and the ugly, everything. Okay, you can't withhold information because you think it goes against your case. There's an actual duty to disclose everything that's relevant. I guess it's important to note as well, when you do disclose everything, and there are some negative aspects, the court's more likely to find you to be a credible witness. It's going to be more likely to accept and believe all the positive things you say because you've actually disclosed the negatives. You become a more credible witness and more weight can be placed on your evidence. Next tip is to make a concession if appropriate. which helps to reduce the size of the exhibit and sometimes the issues in dispute. If you can turn to page 33 of your handout, and I'm just going to give you a couple of minutes just to read those 5 paragraphs there. I just want you to turn one page over to page 34 and just have a quick read of that. Can you see how much shorter those 4 paragraphs are than the previous page, the 5 paragraphs? Probably about half the writing. We've also reduced the exhibit because what we've done is only attached the records which go to the concerns about contact. So when I talk about a concession, what we're talking about is, well, here, contact's generally positive. It doesn't really matter what it is about contact that makes it positive, because the fact that the judge is going to be interested in is that it's positive. So we don't need to worry about including all of those examples. We've included the ones where we do have concerns and then attach it in full so that the judge can read the whole contact report and make whatever decision he or she considers appropriate. Again, it goes to a witness's credit. If you're able to concede points, the court's going to see you as a credible witness, believe your evidence, and again, if you have concerns, might have more regard to those concerns. Sometimes what we do in proceedings is, in fairness to the birth parent, we might create just a separate bundle of documents so that if there are positive records, you might just send the other lawyer acting for the birth parent a copy of all of the contact reports so that you're being open. But generally, and now I've remembered, generally when we're saying it's positive, it's not an issue. And this is what I was going to say. In contested proceedings, we have what's called a preliminary hearing. And at that preliminary hearing, the judge that's hearing it will settle a list of issues in dispute. And if we're able to make particular concessions about some matters, the birth parents also might be able to make some concessions about matters. For example, they might not quibble with the fact that the child has an established relationship with the carers, or that the proposed adoptive parents are capable of providing for the child. So if we can take off some issues in the case, we're going to lessen the hearing, probably lessen the stress for the parties involved. It's going to be a more productive use of everyone's, including the court's time. So that's the other bonus about using concessions, is that we're going to use everyone's time better, and the parents themselves might be prepared to make some concessions. In my view, as a lawyer, wanting to put the best evidence to the court, a file note that has as much detail as possible rather than generalised statements is going to be the best evidence. So, for example, I observed the child was securely attached to the mother versus I observed the child was attached to the mother. For example, whilst I was at the home on the 8th of March 2013, the child sought the mother out for comfort when she fell over. I also heard the child say to her mother, "I love you, mummy." And file notes should also always include details such as dates, where it's located. So let's go back to Jane's monthly review on page 32. You would have read before the 2 sentences under health and development and the 2 sentences under school. Does anyone see any issues with the way that those paragraphs have been written? Who is the paediatrician? It's going to be more persuasive to the court if you can say Dr. Smith on this date prepared a report, and remember our primary record's going to be better, so we probably want the report from Dr. Smith as opposed to this monthly summary. What about the fact that Jane is struggling at school with her reading and maths? How do we know that? It's not very good evidence. A school report might be better, or there might have been a conversation with the school principal or the school teacher. Jane is struggling for these reasons, I think we need to do this. So a file note of that is going to be far better evidence. And also we don't know when. So this monthly review is in April, but it doesn't give it any context. Is this a recent thing? Is it an old thing? So in my mind, if you're preparing a file note, always have in the back of your mind as much detail as possible. Names, dates, details of where it was, that kind of information. Okay, the next tip is that it's important for your legal representative, or sometimes I know that people within the organisation are responsible for drafting, to be aware of all potentially relevant matters so as to avoid issues arising during a hearing. This will also enable your lawyer to make forensic decisions as to whether or not particular information is relevant, and to consider the best way of managing issues and to avoid delays. So I thought I might share with you some examples that I've come across in the last 4 or 5 years. I've had matters where there's been additions to the home and we haven't been told, and of course then there's additional requirements that need to happen, so working with children checks. There's actually notice requirements for other persons in the proposed adoptive parents' home who are over 18. They actually need to be given notice of adoption proceedings. It's not just the birth parents. I've had some surprises arise in the middle of hearings. One was in a case where we had filed some referee affidavits, and we didn't know, but even prior to filing, there'd actually been a falling out between the referees and the proposed adoptive parents, but we weren't told. And often referees aren't requested, but there are certainly times when they have been. And in this matter, the referees were required to give evidence, and it was at that point that we were told, oh, they had a falling out, they don't even like each other anymore, and we potentially were going to have these hostile witnesses who didn't like our proposed adoptive parents. We managed to get away with not calling the referees in that case because His Honour didn't want to hear from them, but we were quite lucky. I actually had a recent case as well where we weren't told, and in fact I don't think the agency was told, that the referee who gave the reference in a personal capacity had actually been professionally involved with the applicants about 6 years ago. Some notes were subpoenaed from a treating doctor who mentioned this person's name, and one of the lawyers for the birth parents recognised the name and realised it was one of the referees. So again, the referee was required to give evidence. The notes were called for in the witness box. We all of a sudden had to read these notes, which we'd never seen before, and there was a whole raft of issues which we'd never been aware of and which we had to deal with on the run. I've had matters where it's come out in evidence that proposed adoptive parents were physically disciplining the children, and we hadn't been given any information prior to the hearing. So when it came out during evidence, we had to try and deal with that issue on the run. Some other common occurrences is where proposed adoptive parents have very different views to frequency of contact. So we've run cases that contact should be 4 times a year. The adoption plan provides for 4 times a year, and then our applicants will get in the witness box and say, oh no, 8 would be fine. Okay, so makes it very difficult. And also another problem we've had is I'll explain it first. With adoption proceedings, with the out-of-home care, when we go to court, you have to undertake a risk assessment under Division 1A of the Care Act to work out whether or not there would be some risk in the release of personal or identifying information of the applicant, so surnames, place of residence, place of employment, the child's school. And after that risk assessment, a decision's made about whether or not to disclose a surname. And as part of that risk assessment, you seek the views of the proposed adoptive parents. But we've had cases where we've had the risk assessment, sought to redact that information, and then again, they've gotten in the witness box and said, oh no, they can know my name, that's fine. Okay, and it's a bit embarrassing before the court. So from a risk management perspective, if possible, always provide your complete files to the lawyer preparing your case, rather than just giving them the information that you want included. You might not realise something's relevant, you might overlook something, whereas our role when we're preparing the application is to go through your files and extract all the relevant information. So from a risk management perspective, I would really encourage you to provide your complete files to your lawyer.